The future is never certain, but there's one thing you can do to help give you some ease of mind. In today's video, we discuss the top 5 things you need to know when it comes to estate planning in Illinois. Come on in and have a seat. I'm Ben Weaver, Illinois attorney and founder of 23 Legal. I provide personal, practical, and professional legal service by guiding clients through the process of buying and selling a home throughout Chicago and its suburbs. But today, we're going to veer just a little bit off that real estate path and look at estate planning. What you want to be sure you have set up, and what happens when you pass without a will or a trust. Number 5. What is probate? Well, probate is the formal legal process through the judicial system to wrap up an estate. If someone you love passes without any documentation about how to handle their estate, and the family cannot agree on how to proceed, then the estate will enter what is called probate. Through the probate process, a judge reviews the will and appoints the executor who will manage the estate until all issues have been resolved. From this point, the hope is that selling the estate is smooth sailing with the executor's guidance, and if there are any disputes that cannot be agreed upon that can cause the court to get more heavily involved, and the length and cost of probate will rock it up. There are ways to either simplify the probate process or avoid it completely, so let's look at those now. Number 4. What does a will do? Well, when you traditionally think of a will, you likely are picturing the last will and testament. This is what you see in those Hollywood movies where someone leaves a list of personal belongings and divvies up their assets to their family and closest of friends. The last will only becomes active after the death of the person whose will is the name it's in. The 3 main details included in the will are executor. You get the opportunity to name who you'd like to include as your executor of the estate. Guardians for minors and dependents. Who will care for your children if you pass away? Well, now it's your chance to place your selection in writing. And the bond waiver. One feature of a will that doesn't get enough attention is the bond waiver. You see, in Illinois, an estate must purchase a bond equal to a minimum of 1.5 times the value of the estate, unless this bond requirement is specifically waived in the will. A will doesn't necessarily excuse your executor from opening up a probate estate. However, the directions provided in the will can save your estate valuable time and thousands of dollars between court costs, attorney fees, and those bond payments. Number 3. Want to avoid probate court altogether? Well, let's look at a trust. What is a trust? Well, a trust is a living entity that officially owns your assets both during your life and after you pass away. Typically, the person who creates the trust is the initial trustee, and it has full authority to buy, sell, and manage any assets owned by that trust. Once a trustee can no longer manage the affairs of the trust, the obligations and duties of the trustee are passed along to the initial trustee's handpicked successor. Essentially, the trust privatizes your personal assets to help avoid the need for a probate judge to act as an arbitrator of those assets. Number 2. What is the power of attorney for healthcare? Well, in a similar manner to how a trustee would handle your living will, the power of attorney or POA for healthcare makes decisions about healthcare and quality of living for the grantor. The POA for healthcare takes effect at your discretion, which could be right away or upon a certain event happening. This will allow your agent to start making difficult medical decisions on your behalf when needed. There are some major decisions about your power of attorney agent can make for you, so please make sure you've chosen someone you know you can trust with your best interest in mind. Number 1. What is the power of attorney for property? Well, similar to POA healthcare, the power of attorney for property will make decisions about your finances and belongings for you. They'll help from small things like paying bills, balancing a budget, and handling insurance, to more complicated financial matters like running a business, mortgaging property, or handling your entire estate. This too should be someone you can trust with everything you have because, well, that's literally what you're doing. One last note about the POA. You must decide who can be your power of attorney when you're able to make that decision for yourself. A POA cannot be signed to after illness or injury renders you unable to make that decision. And, sadly, you never know when that day may come. So it's always a good idea to get the jump on taking care of your estate plan. Well, those are 5 things you want to know about estate planning. There sure is a lot that goes into securing your future, your belongings, and your legacy. And the process can take a few months, so please, if you have any questions, contact 23 Legal. We'll help you through it. Like this if you found it helpful, and be sure to subscribe for more real estate and estate planning content. I'm Ben Weaver. We'll be taking new contracts and clients, and I'll see you in the next video.